case law which had settled that if you seize an article, or if an accused points out an article, discovers an article, that article should be immediately seized and sealed in the presence of the panchas. And it should not be tampered with till it reaches the chemical analyzer or whatever the scientific body it is sent to. Now, there are 2-3 recent judgments of the Supreme Court which say that all this is bakwas. Even if you display those articles in a press conference, the police displaying that article in the press conference, there is no disturbance to the discovery under section 27. The seizure, Panchanama, or if the articles are seized at a place, they need not be sealed on the spot. They can be sealed in the police station after the articles are taken to the police station. Now, I will refer to those judgments one by one. Now, seized articles were displayed by the police in a press conference is no ground to disbelieve the discovery. That is 2002 Criminal Law Journal, page 944. 2002 Criminal Law Journal, page 944. Then the second party, I'm very sorry. You will have to find out the equivalent. Then the second thing is sealing of articles on the spot is not necessary. Sealing at the police station is good enough. That is 2002 Criminal Law Journal, page 967. 967. Now, another boundary which has been scored by the Supreme Court is that seal is not at all necessary. In one case, they have observed seal is not at all necessary as long as the parties identify their own ornaments. No seal is required. And that is 2004 SCC Criminal. 2004 SCC Criminal, page 713. Then the next is that, while recording a confession, a judicial magistrate has to ask certain questions. First, the initial confrontation between him and the person who is confessing, and then some time given for reflection to that person, maybe 24 hours, maybe 48 hours, after which he is brought back. And then again, certain questions have been asked. The format of those questions have also been given under the Code of Criminal Procedure, and certain rules which have been framed by various high courts. In criminal manual of published by every high court, you would find these rules. Now, the Supreme Court has come out with an observation in which it says that the confession recorded by a magistrate, even if questions to ascertain voluntariness is not put, it is still admissible. The magistrate does not put any questions to verify the voluntariness of the confessing accused. In spite of that, the confession would be admissible. That is 2007, volume 2, 2007, volume 2, SCC Criminal. SCC Criminal, page 1. Then, as you know, connected with this confession, the settled law was that a confession has to pass all the tests which have been laid down under section 164 of the Code of Criminal Procedure. For example, if the magistrate who records the confession had no power to record the confession, he may have been a second-class magistrate who had no power to record the confession, then it can't be said to be an admissible confession. That was the observation earlier by the Supreme Court, long back. Then it was also held by the Supreme Court itself that if the magistrate had no power to record the statement, then he can't come as a person to depose about the so-called confession as an extrajudicial confession. That was the earlier law, that the magistrate who has no power to record the confession becomes inadmissible. Can he alternatively come forth as a witness treating that confession as an extrajudicial confession? Because extrajudicial confession could be made to anybody, and it could be made to a magistrate also. Therefore, whatever he had recorded, he could not record, but he had heard it from the mouth of the accused, and therefore it could be treated as an extrajudicial confession. Supreme Court earlier had said, no, It cannot be even treated as an extrajudicial confession. But now the Supreme Court says that when a confession falls short of all these requirements, when it falls short of even admission of guilt, then it may be used as an admission under Section 21 of the Indian Evidence Act. It can't be treated as a confession, but it could be treated as an admission under Section 21 of the Indian Evidence Act. And that is 1998, Volume 1, Bombay criminal case. You'll have to find out. This is a Supreme Court case which was reported in 1998, Volume 1, Bombay criminal cases, page 631. 631. Then the next, Section 30 of the Indian Evidence Act, which deals with confession of a co-accused. Now the law, settled law was that a confession of a co-accused may be taken into account as far as the rest of the accused are concerned, but it can't be made the basis of conviction of the remaining accused. Now the Supreme Court says that confession of a co-accused, if found acceptable, can form the basis of conviction without corroboration. So even another person, your co-accused, confessing, there were so many guidelines laid down that he must tar himself with the same brush with which he was tarring others. Now here it says that it need not, you don't go for any corroboration. You just refer to the confession of a co-accused. If it satisfies you, you can convict a man without any other corroboration. Not that man who confesses. He could be confessed, of course, that is simple logic. But other accused, co-accused also could be convicted without any corroboration. And that is 2003, All Maharashtra Reporter Criminal. All Maharashtra Reporter Criminal, page 2365. 2365. Then the next comes, there are two judgments which were given by the Supreme Court in 2002. While cross-examining a witness, the defense lawyers are in the habit of giving suggestions right and left. Now in future, don't do that. Don't do that. The simple and the most innocent and non-controversial suggestion would be you are telling a lie and sit down. When you are making suggestions, that should be the only suggestion that your evidence is false. You are giving a false evidence. That's all, and sit down. Of course, substantively you can cross-examine the witness. But if you suggest something, you make a suggestion to a witness, that suggestion has been denied by the witness. The Supreme Court in two cases in the year 2002 has held that suggestion, though denied, would be taken to be the case of the party. That means you would be saddled by the stupidity of the defense lawyer who has been cross-examining. That means if the lawyer goes on giving, you give contradictory suggestions many times, that is it a fact? Therefore, always be very careful. Your 1 year should be to the judge who records the evidence, that you can suggest to the judge, sir, this is not my suggestion. It may be taken in a narrative form, or it may be taken in the form, it did not happen. It did not happen. But don't say, it is not true, that this is the manner in which it has happened. If you suggest something, it would be taken to be your own case, your defense. And you would be saddled with that case, though it may have been denied by the person. Now that these two cases are reported in 2002, SCC Criminal, pages these are two different cases, 217, 217, that is the first case. And the second case is 1568, 1568. Same volume, 2002 SCC Criminal, 217 and 1568. Read these two cases very carefully. Many of the lawyers have not read these cases because they are very, otherwise they are not very important. But this thing would be, your pitfall would be there in those two cases because many of the judges have come to know these cases now. Because I go to Bhopal to teach some of these judges in that National Judicial Academy, wherein many new things are being taught to the judges. Therefore, they know these things. And they would be they would be using them against you. They would be telling you, sir, this is If you make a suggestion, it would be taken to be your case. So be very careful. As you know, in Best Bakery case, the next point is that in the Best Bakery case, in view of the circumstances which were very peculiar in that case, the Supreme Court ordered reinvestigation, not only re-examination of certain witnesses who were dropped right and left by the prosecution, and the observations were that the prosecutor was acting more as a defense lawyer rather than the prosecutor. And those were the peculiar circumstances in which all agencies of the government had joined hands. The government, the police, the prosecutor, and the court fell in line and then finished off the case in no time. It was real fast track. Vijay had given me that Justice Parshikar's observations in the Bombay High Court that these fast track courts are okay, but fast track doesn't mean dispensing with justice. Fast dispensing with justice. Now, therefore, that was a peculiar phenomena. But then, as a result of Best Bakery, many cases started digging up their old cases, saying that this was not properly done, that was not properly done. And they were probably trying to settle the old scores with their enemies. And therefore, the Supreme Court had to come out with an observation later on that Best Bakery had its own peculiar circumstances available in that case, and therefore we had to make those observations. But don't make it applicable in every case, which is a good thing according to me, that if you want that later case in which the Supreme Court observed about Best Bakery's earlier judgment was 2005. 2005 SCC criminal 276. 276. Then the law which was very much settled, I would say, that if an objection was raised by the party while the examination chief or the evidence is being recorded of a witness, then that should be settled then and there by the judge, whether a particular thing is admissible or not admissible. Now, much water has flown since those days. Judges, recent, I would say fast track judges or even other judges, regular judges, they are incapable of deciding this on their own. Therefore, what they do is that they say this would be decided at the time of final judgment. Now, that has been now given an official, I would say, recognition by a judgment of Justice Thomas that nothing should be decided there. You write down the objection taken by the other party and keep it back for the final judgment in the case, because if you decide one way or the other party which is aggrieved would go in appeal or revision, and therefore matters would get delayed. That is the observation of the Supreme Court, and that is in AR 2001, Supreme Court, page 1158. Then the next is, you know that what was the scope of re-examination as far as sections 137 and 138 of the Indian Evidence Act was concerned? What was the scope? In old days, we always used to say that the scope is very limited, and if there is any ambiguity, then that could be explained by the prosecution in the re-examination. But now the floodgates have been opened by the Supreme Court, again by Justice Thomas, by saying, no, not necessary. You can allow anything in re-examination, anything under the sun. Anything under the sun, as long as it is relevant. And those are I could find only one. He has given two judgments actually on this. But the basic judgment is 1999, Criminal Law Journal, page 4561. Then the next is the Supreme Court, as he says, unmerited acquittals are no good to the society. That is the observation of the Supreme Court, unmerited acquittals. Of course, merited or unmerited would have to be decided by the evidence and not by the TV stations or by newspapers or what the media thinks. That judgment is 2004, Volume 2, Bombay Criminal Cases, 140. Then the next is, as you know, that certain safeguards were provided for in the Criminal Procedure Code to have some protection to the accused from the police machinery. One of them was that the first information report which has been received under and which has been recorded under Section 154 of the Code of Criminal Procedure, a copy of that first information report should be sent forthwith to the nearest magistrate. And that is Section 157 of the Code of Criminal Procedure. Under Section 157 of the Code of Criminal Procedure, a copy of the FIR has to be sent forthwith to the nearest magistrate. Now the Supreme Court has come out. There were a lot of tangent judgments of the Supreme Court on this as to whether this is really strictly to be followed or whether it is non-mandatory. Whether how much time delay of how many hours or how many days would be taken to be fatal to the prosecution. All that discussion was there one way or the other. And finally the Supreme Court says that forget about this provision of 157, it is not that mandatory. Now that is the latest judgment of the Supreme Court, which says 2006 Volume 2 SCC Criminal, 2006 Volume 2 SCC Criminal, page 484. 484. Then the next is, I don't have the judgment, but it was reported in the press that recently, as you know, that very double standards are being used by the Supreme Court. There was an observation in one of the, it must have been reported by this time, that for these politicians and others found in corruption matters and in criminal offences, the prior sanction under Section 197 of the Code of Criminal Procedure need not be taken. The Supreme Court has said that prior sanction not necessary in cases like that. When you misuse your political post or your public post, there is no necessity of a prior sanction under Section 197. But the same holier-than-thou attitude of the Supreme Court has been refusing to have that collegium. They don't want really. They really don't want that collegium, judicial collegium to be formed. And they are also steadfastly refusing to accept truth as the defense under the Contempt of Courts Act. They have refused. They said no. It would bring to disrepute the entire system. That is what they are worried about. That is my charge. Everybody is worried about not a few Jessica Lals or this or that. They are worried about the system being exposed to the common man for what it is. That is the whole purpose of these cases. That is my charge. And this they have indirectly accepted. They say that there is every likelihood that the system itself the common man might lose faith in the system of judicial dispensation in this country. I will give you that case. Yes, that is AIR 2003 Supreme Court. AIR 2003 Supreme Court, page 4567. 4567. Supreme Court worried about the common man losing faith in the system of judiciary itself. That exactly is the worry of the politicians, of the judiciary, and the establishment. Then we go to a couple of more things before I close. We were told earlier that punch should be from the locality from where you collect that article or somewhere. You have to explain why that particular punch was selected. The Supreme Court has held the punch need not be from the locality, but even a policeman could act as a punch. This is the latest observation of the Supreme Court. Even a policeman could act as a punch. And that is 2005 SCC Criminal, 2005 SCC Criminal, page 1999. Then another case which says that the eyewitness need not be what you call a natural witness. That means he should have been from the locality where the incident had taken place, or that he had some reason why he went there. That reason should be acceptable reason. A man cannot say that at 2 o'clock in the night to answer the call of nature. The Supreme Court in an earlier case had said these are nature's call witnesses. That means they had no other excuse than saying that I had a nature's call, and therefore I went at the end of the village where the murder was being committed instead of being sleeping in the house, and therefore I am a witness to the crime. Now they were called nature's call witnesses by the Supreme Court earlier. Now the Supreme Court says nothing doing. He need not be from there. Anybody could come forward, and the question is believing. And when what is the test of believing? As Malimat committee has said, the judge feels that it is true. It is not reasonable doubt or presumption of innocence, nothing of the sort. It is the judge's subjective satisfaction that the man is guilty and therefore he should be punished. That is the criteria which the Malimat committee has. Now here the Supreme Court says that this eyewitness need not be from that side. It need not be what you call a natural witness. That is AIR 2004. Supreme Court, page 5050. 5050. Then we were accustomed to the old law which said that extrajudicial confession is a very dangerous sort of evidence. You know, it is a very slippery type of evidence. Anybody could come forth and say that so and so came before me and then he confessed before me. You had to go into the background of this witness, whether he had any connection with the confessing accused, whether he was a person of confidence of the accused, whether there was any reason or occasion for the accused to confess to him. And all those details had to be proved by the prosecution to make him believable. Now the Supreme Court says that forget about it. An extrajudicial confession can be made even before a stranger. And you can believe him. That is 2007, page 2, volume 2, I'm sorry, 2007, volume 2, SCC criminal. There are two cases here. One is on page 1 and the other is on page 115. Then there have been, every now and then the Supreme Court has toyed with the idea as to whether really false defense could be used against the accused. They were very much enamored of this proposition as to whether a false defense could be used against the accused. As you know, every accused who denies to have committed a murder would be guilty of this proposition, that he denies falsely his involvement in the murder. That means every other accused who is being charged with a crime would have a circumstance against him because he is falsely denying his involvement in the offense. But the Supreme Court finally has decided to give a sanction to this proposition. It has held now that a false defense which has been taken by the accused is a circumstance against him. A false defense taken by an accused is a circumstance against him. That is 2003, Criminal Law Journal, page 1210, 1210. Then it says that eyewitnesses and medical evidence. The settled law was that if there were contradictions between the two which would falsify the eyewitness, then medical evidence should be preferred, if that is acceptable. Now the Supreme Court said forget about medical evidence. If eyewitness is acceptable, forget about medical evidence even if it may be totally contradictory with the eyewitnesses evidence. That is 2003, SCC criminal, page 32. Then that famous judgment from about a doctor from Dr. Prafulla Desai from Tata Hospital, Tata Cancer Hospital from Bombay, wherein this cross-examination by video conferencing or on telephone was accepted by the Supreme Court as a proposition. I don't know how many of you have come across this video conferencing. I have in number of cases in Maharashtra, where I find it is a useless medium, absolutely useless. It breaches all the provisions of basic criminal law. Now, supposing you are cross-examining a witness on the basis of video conferencing, many times in the middle of the cross-examination, you have to take instructions from your client. The judge is sitting there. The witness is somewhere else. We had a situation wherein the witness was in the box. My man was in the Yeravada jail in Pune. And we were cross-examining that eyewitness, taking instructions from that person who was in Yeravada jail. How could I? What was the confidentiality between the client and lawyer? That I would be asking my client. Now, he was in jail where there were other policemen around. He was on the screen which judge could see, witness could see, the parties could see, prosecutor could see, the public could see. And I was supposed to cross-examine this witness in the court, taking instructions from my client. Now, video conferencing in an innocuous way maybe for remand reports and other things maybe, but otherwise video conferencing is absolutely useless. But the Supreme Court has held, that is AR 2003, Supreme Court, page 2053. 2053. Here, what had happened was Dr. Prafulla Desai, who is one of the renowned cancer surgeons in India, he had advised a person whose wife was suffering from cancer that we would perform her operation. And there are some chances of prolonging her life. Therefore, this advice was given by him. Then what happened was that this person contacted another specialist from United States who said that there is no point in undertaking this operation. This woman is not going to survive. But in spite of this second opinion, he went ahead with what Prafulla Desai told him, and the operation was performed. The wife died. Yes, this is the last. The doctor from, then he filed a case against Prafulla Desai, and he cited this doctor from United States as a witness who refused to come to India. Therefore, this video conferencing was suggested. And the Supreme Court held that forget about the provisions of section 273 of the Code of Criminal Procedure, which say that evidence has to be recorded in the presence of the accused. They interpreted the presence, the word presence, as not necessarily physical presence, but it may be presence through his lawyer. And therefore, it need not be in the presence of the of his personal presence, but it may be for through his lawyer. Now, that is that case by which video conferencing was allowed by the Supreme Court. Now, the last thing which before I sit down, is as Colin has said, that 313 statement of the accused, in which we have been given a statutory right of keeping quiet, not opening your mouth. You need not even, you can refuse to answer questions. That has been substantiated by even Article 20, Clause 3 of the Indian Constitution. The Malimet Committee suggestion and the amendments which are pending suggest that 313 statements should be now remodified, recodified, and all those, like a civil litigation, that you submit your defense in advance, you indicate what is going to be your defense, and the prosecution should not be taken by surprise, and all those, which go to the very root of the basics of Indian criminal jurisprudence. Now, these are some of the instances which I gave you. Some of the case law which I have cited is available and is being circulated. You can go through that. Some additional thing, if they become available, we'll try to circulate them also. Thank you very much.
That was such an excellent, and I suppose all of you will agree with me, such an excellent and broad presentation. Now we quickly take comments, very short but quick comments, before we move to the next session. Is there anyone who would like to say something, or we could move to the next?
About this sealing, I was fascinated. I'm Chandrasekharan, forensic scientist. The sealing, especially in the Mattu Priyadarshini case, change of custody, how the entire miscarriage of justice later was displaced. To avoid that in Tamil Nadu, the scientists directly we go to the crime scene, we seize the object, we take with them, we don't give it to the police. We record like that. And that system we followed even in Gandhi's case. That means minimum number of people handling, so that sealing is done at least only one source. To be of interest, I received an object which I was examined, put my seal, without breaking my own seal, as if the object was seized in another case, prohibition case, after 2 or 3 years. Along with my seal, the police put a new seal and sent back to me.
Well, I'm Advocate Ibrahim from Ernakulam. Well, in fact, the Supreme Court, as he is now very expertly exposed, the Supreme Court in various cases, making the entire judicial system upside down. As a matter of fact, the mens rea, which is the basic, the fundamental principle for in every criminal judicial system, especially in our Indian system, I mean, that has been given a go by. Now, the judges, like Mr. Collins said in his introductory speech, that they are very quick and hasty to come to the conclusions. The result now is that the police is now being armed to charge anybody, and the person who is accused has now to prove that he is the entire burden shift to the accused. The entire burden that I am innocent. I mean, which is a provision perhaps you will find in TADA and other terrorist cases where the burden is shifted that I am innocent. The presumption is that he is guilty. Now that presumption is now indirectly brought into the Indian Penal Code. As a matter of fact, Supreme Court has been interpreting all these provisions in the Criminal Procedure Code and Evidence Act with respect to the recovery of the articles, confession, all that. They are traveling beyond what the statute has given. Supreme Court is after all to interpret it and not to undo the provisions. Now, almost all provisions in the statute has been, by interpretation, be undone. Now, that is the protest which we should say. And we should say that all this judgment, insofar as it go against the mandate of the provisions in the Criminal Procedure Code, Evidence Act, even the Constitution, Article 23, which gives you to be silent. You know, even that, which is a fundamental right, even that is being overlooked by this kind of quick treatment, which is something very deplorable. Thank you.
You know, I was the first to respond to Malimat Committee's report twice. First, when they sent the questionnaire, which is published in the Madras Law Weekly. I wrote an article criticizing the questionnaire. Then the next time I wrote was when the report was sent to me by Colin to immediately respond to it. I responded, and my response was published continuously for 2 days in the Hindu during that period. Now, my problem with Malimat Committee is none of the members, including the chairman, had any criminal law experience. Neither Madhav Menon knows any criminal jurisprudence, nor Malimat knows any criminal jurisprudence. Not only the judges. Judges, of course, have been there for a long time who had no criminal practice at all. And I remember Mr. A.S.R. Chari in those days. I am 53 years in the profession today. Mr. A.S.R. Chari told the bench that it is unfortunate that no person who knows criminal law has been elevated to the Supreme Court till now. He was not asking for his elevation because he was a leading counsel, leading criminal lawyer. But he found the abysmal ignorance of judges. And very often what happens is that when they look at things, they deal with words, not the life behind those words. They deal with empty words, just the words, and some semantic jugglery is done. Beyond that, they have not done anything. So far as confessions are concerned, if the subordinate judiciary is alive, none of these confessions will pass muster. None of these confessions. All my life I have defended Naxalites, and I found that even confessions recorded by a police officer, confessions recorded by the judicial officer, have all been thrown out. Not one of them believed. That is because the district judge at the lowest level sees the impunity with which the police behaves. And so he assesses their evidence, taking into account the impunity of their conduct. So what is happening in the higher level is they are more and more dependent on the police. More and more dependent on the police. Because you have got to be anti-people, you are afraid of the people. You always think that people are insurrecting against you. All the time the feeling is there. So you find a judge like K.T. Thomas. He wants to convict people. There have been judges like this, that he is a convicting judge. We also say, advocates will also say, he is a convicting judge, let us not have the case before him. Because that takes me to another topic saying that this profession is not structured to deal with law in the manner the Constitution expects them. You refer to a Constitution when it has advantages to you, not otherwise. So even for the profession and the judiciary, there is a certain amount of constitutional discipline is necessary. If that constitutional discipline is not necessary, you have this kind of bad judicial governance in terms of law. That is what is happening to this country. Almost all the institutions which participate in the justice system are very degenerate, very corrupt, and they enjoy tremendous impunity in the manner of dealing with people's lives. That's what I want to say.
Thank you, Kannan.
I'm Shankar Subbu from Chennai. I supplement Mr. K.G. Pranavaran. In this dying declaration, without the mental statement of the mental statement from the doctor, it had caused a havoc. One example in my case, one of the accused said that is why you remove your head of the accused. I moved an application for bail. And I asked him why you removed the head. Because of the judge is not granting bail. He said that is when, if I not remove the head, they will get a dying declaration. So even that is a position. So that is, such is the thing that overruling the Papamas case is very bad, and it has got to be, reviewed. That is a mental statement of the accused person. A mental statement of the deceased is a must. And then regarding dying these confessional statements, these co-accused confession statement that is making havoc, and without anything that based upon the confession, the co-accused confession, that is in Jamil Ahmed's case, and based upon things in the all Tada cases in Tamil Nadu, the co-accused confession is alone is the basis. On that basis, all the Tada detainees were convicted, and a maximum sentence of not less than 5 years to 10 years were imposed. That he just helped him, gave him some food and other things to the principal accused. He offered some food and other things. So that is a position. Apart from that, judges also differ. In one case, one judge says that a person, Devendra Pal Singh's, the confession, why should he make a confession? He is a person considered to be a topmost terrorist. In such cases, why should he make a confession? So that is on that basis, the entire confession has been rejected by the senior judge, M.B. Shah. But on the other hand, another judge, Arjit Pachayat, imposed a death penalty to a person based upon this solitary confessional statement, which is involuntary according to the senior judge, M.B. Shah. So that was a position. So it requires that is confession to the police officer. It was referred to the judgment of K. Ramasamy, and even recently also that is in the parliament attack case, Justice Reddy said that it requires a relook, that is the Kartar Singh's judgment has to go, and Article 20 and 21 has got to be protected. That is my view.
I'm B.T. Venkati.
Shankar Subbu.
Koda from Jodhpur. I would like to submit something because there is no. As far as the proposition laid down by the Supreme Court is concerned, there is no doubt about that. That entire law has been changed now. My worry is because the whole problem is this, that how we now take this challenge, because if these propositions are in the form of the law now, and the lower judiciary has to obey all these things which has been done by the Supreme Court, then how we change it? Because now this whole worry is this, how we'll go for that. Because if the first proposition, that the functioning about this fast track courts, because I don't know what about the other states, but in the state of Rajasthan, the junior most person is working on a post of on the courts of the fast track. Junior most. A person right from the ACGM directly come into the fast track as the sessions judge. And they are much they are the persons who follow these propositions very soonly. Because they don't have any experience. You just take it the thing. A person who has not even conducted a trial of the 326 only, 325, directly now conducting the trial of the 302 and 376. So, the earlier law, which is, because this is not necessary to follow all these things, because there are the other things, the other law is there. If experienced judge is in front of him, if the trial is going on, probably he may